Thank you, Lance. My name is Joel Talbot, and syndicated I'm with the family office here at Lavelle. My presentation today is regarding the issues of premarital and post-nuptial agreements. And I'm going to give you a slight overview as it relates to what these agreements are, how they're used, and why they're important, why people should consider them when they're contemplating marriage. Do you have any questions as I'm presenting? Feel free to ask them because I'm going to have to leave to go to quote question today. What is a premarital and prenuptial agreement? You may have also heard antenuptial as being another word. These are agreements that are made between prospective spouses in contemplation of marriage. What does that mean? People who are going to get married or involved in a civil union get together, they prepare a contract, a written agreement, which is a roadmap to certain issues that will be addressed in the event of divorce. What are those issues? Those are mostly financial issues as it relates to what they're going to do with their property that they acquired before their marriage or during the marriage. Also, what happens to their property that they further acquire or the increase in value of that property during marriage. It addresses issues of division of assets. What happens in the event of a divorce? Who gets what proportions? How are they divided? Also, debts. What do we do with debts that are acquired during marriage? Also, taxes. What are the tax implications for any property that's going to be distributed during the marriage or as a result of a divorce? And spousal maintenance, which is known as alimony. That's one specific area. It gets a little bit tricky when we do premarital agreements, especially when you have high asset cases and where parties they have large amounts of income. The most important thing to remember about these prenuptial agreements is they must be in writing. They have to be signed by both parties. No verbal agreements, no written document that both signed. It doesn't contain the language necessary to make the premarital agreement enforceable. It's going to be able to be used or enforced in court in the event of a divorce. Who may want a prenuptial agreement? Why we might want one? Non-marital estate. It's important to understand that in Illinois, there's a distinction between property that's acquired prior to the marriage and property that's acquired subsequent to the marriage. Any property that parties have prior to their marriage is known as non-marital property, which means normally in a divorce, that property, so long as it stays in its state at the time of the marriage and at the time of the divorce, remains that party's non-marital property. That could be any type of asset. That could be a home, it could be a bank account, it could be a retirement account, it could be personal property. So addressing that issue as it relates to a prenuptial agreement is one specific area that we'll look into. Family businesses. This is very common for parties who are contemplating marriage and have an interest in the family business, whether it's current or in the future. And in most cases, where there are close family businesses, small companies, LLCs, or even S corporations, things of that nature, where there's family members involved. These are very important areas where parties who are getting married may consider a premarital agreement to protect their interests. The reason being is in the event of a divorce, it's not uncommon in family business situations that the partners and other shareholders are drawn into the divorce. Not by choice, but because of the process. It opens up investigations into assets, income flow, debts, things of that nature. Another reason parties look for prenuptial agreements is if either one of the parties have been divorced prior, which means they've been through the process once before. They also have assets that they've acquired prior to the marriage that they want to protect. And they also are concerned about what happens in the future in the event of a divorce. So those are one of the things we look at as well. Also for the protection and distribution of assets to children or other family members. This is also a very important thing. A lot of older couples or second marriage couples agree with the prenuptial agreements to protect the assets that they want to give to their children. So if you did not have a prenuptial agreement, it was your wish to transfer assets to one of your family members, your children, or relatives. And in the event of a divorce, that could be something that wouldn't be protected. The prenuptial agreement will help protect those type of issues. And you can also address issues regarding estate taxes. If you have a large trust or an interest in a beneficial interest in any type of a estate plan, you want to make sure that that issue is addressed as far as what happens in the event of a divorce. Gift taxes and trusts as well. So all these different areas are things that are affected and can be protected by the use of a prenuptial agreement. What can be included? Rights and obligations of each party in the property, either both of them, whenever, wherever required or located. This means what happens to every asset that we have. You can include those assets and say, in the event of a divorce, this is what we're going to do with these specific assets. We identify those assets in separate property for each one of the parties, and we say, this is what's going to happen in the event of a divorce. It also allows you to determine what happens during the marriage. What if we buy a home? What if we purchase some other type of an asset? What happens with that property? Is it going to be one of ours, myself, or my future spouse, or is it going to be ours together? So those issues can be addressed as to what happens. What happens with the sale of any assets, or the transfer, or the exchange, or the mortgage of any property, and what we do with property that we have acquired during the marriage and prior to the marriage. The disposition of property upon termination of the marriage by death or the occurrence of any other event. This means that in the event of a divorce or even the death of a party, if a divorce action is pending in that situation, and if the agreement is enforceable by the court, in that situation, the court will allow that agreement and its terms to be enforced in the event of a divorce, and the estate of that person who may be passing, who's still in the divorce, will not be affected. And the elimination or modification of spousal agreements is relevant. This is a very difficult topic at times as it relates to what happens in the event of a divorce if the parties have a prenuptial agreement and there's an issue of maintenance. In Illinois, the court looks at the income of both parties in the event of a divorce to determine whether or not the party is entitled to maintenance or support from the other spouse. A prenuptial agreement can limit that amount of maintenance or spousal support that could go to one of the parties if the language is specific and if it's such that the court believes it's not unconscionable, which means that it's reasonable. Get to some other issues that relates to that as we go forward. What can be included also is the making of a will or a trust or an arrangement to carry out the terms of the agreement, which means you can put specific language in a prenuptial agreement that addresses what happens to my estate. Does my current spouse have an interest in it or not? And I can preclude that spouse from having an interest in it, and vice versa, or we can limit what the rights of that spouse would be in the event of a divorce. Choice of laws were also very important. What happens in the situation as to what law is going to govern. Here in Illinois, we have an Illinois premarital agreement statute that basically sets forth what those rights and obligations are for the parties as it relates to premarital agreements and their enforceability. It's very important that any premarital agreement include language as to what states' laws are going to be interpreted as it relates to enforcement of that agreement. The reason being is that every state has different rules, laws, and regulations as it relates to the enforcement of premarital agreements. So it's important that when you choose choice of law, that you indicate which states you're going to have the law applied to. And then any other matter, including personal rights or obligations that don't violate public policy or any criminal statute. So any term in terms of a prenuptial agreement can include all types of things. I'm going to give my wife $20,000 for this, or even a language that says, in the event my spouse does some type of an act that's not in the best interest of our relationship, has an affair, things of that nature, they negate or lose any benefit that they would have under prenuptial agreement. So these type of terms can also be included in the agreement, and we also include any other issues that the parties may have as it relates to specific circumstances that might arise during marriage to address those. What cannot be included? Things that cannot be included, anything related to children, child support, visitation, parenting agreements, all those issues related to the children, their support, any issues that relates to children, it's not something that could be included in the agreement. If parties try to put that in an agreement, the court's going to set that aside. So that would be something that's separate and apart from any division of assets or prenuptial agreement would address. When does it become effective? Prenuptials are only effective when the parties get married. If there's no marriage, the agreement is not enforceable. Okay. So a lot of times you'll get a situation where the parties say, well, I had this prenuptial agreement. Well, we didn't get married, but I want this asset. No, sorry, that doesn't work. Because when you file a petition for dissolution of marriage and you have a prenuptial agreement that the parties have already executed, in that situation, you have to include in your petition or request the existence of that agreement. Okay. So the court then knows, and everyone is put on notice, that there's this prenuptial agreement that the court must consider when it makes a determination regarding the division of assets and other matters in the divorce case. So only upon the effectiveness of marriage and or a civil union. It applies to civil unions as well. So without that, there would be no enforcement of any agreement. When is it not enforceable? This is an important aspect. Most litigation as it relates to divorce cases where there are prenuptial agreements is an argument that some portion or all of it is not enforceable. When is it not enforceable? When the one party did not execute it voluntarily. What do we mean? They were coerced into sign or threatened. Or they signed it under duress or threat. What could those issues be? Coercion? If you don't agree to sign this prenuptial agreement, we're not going to get married, and that's the end of it, or I'm going to disown something or the other. Those type of things are coercive in nature. And if in fact the court determines that there's been coercion as it relates to any party entering into any part of that agreement, the court can set it aside or set aside those provisions that were coerced. Signed under duress, or threat, same type of situation. When does this normally happen? Parties execute agreements too close to the marriage date. And it makes obvious sense. Even though a party may be represented by an attorney in certain situations, if the marriage date is coming up quickly, it's not uncommon for the court to say, let's take a look at this and see how this all came about. Because one party might say, look, I felt like I had to do this. Our wedding date was coming up. He said he wouldn't marry me unless we signed this agreement. And I've actually represented parties in these types of situations. And even though the agreements were valid in every form and fashion, enforceable, and there was full disclosure and things of that nature that were required for the agreement to be valid, the court will still look at that issue that believes there was some type of duress as it relates to the closeness signing an agreement to a marriage. So that's important as well. The agreement was not unconscionable when signed, and before the agreement was signed, that party was not provided a fair and reasonable disclosure of property. In a prenuptial agreement, there must be fair and reasonable disclosure of all assets and all financial interests of all parties. If there's not a full and reasonable disclosure, that's a basis for the court to set the agreement aside, which means it's not enforceable. That includes assets that you have prior to your marriage. It also includes your income that you're earning. So we normally have an exchange of all financial documents for both parties as it relates to their tax returns, current pay stubs, things of that nature, and all financial information, including debts, is part of the process of determining whether or not there's been this reasonable disclosure. Another reason, the party did not voluntarily waive in writing disclosure of the property or financial obligations to the party beyond the disclosure provided. What does that mean? In the agreement, there's no provision as it relates to a party waiving the right to further disclosure. So in a prenuptial agreement that we normally prepare, we have language that specifically says the party has been advised of the financial disclosure of the other party, has full knowledge of what that information is, and they voluntarily waive that as a part of the prenuptial agreement. So that language is normally included in the prenuptial agreement to avoid this aspect before the agreement being set aside. Another reason, the party did not have, or reasonably could not have, adequate knowledge of the property and financial obligations of the other party. Again, if there's someone hiding an asset, which is not uncommon, or in fact, it's discovered later in the process after the marriage that there was an asset that was there, or a debt or an obligation that was not properly disclosed, which could have a severe effect on the distribution of assets in the event of a divorce, that would be a basis for which the court could say this is not an enforceable agreement. Also, if the modification or elimination from spousal support is causes undue hardship or circumstances to parties that was unforeseen, the court can set aside that portion of the agreement regarding spousal support or maintenance. What does that mean? Someone becomes seriously ill. There's a substantial change in the physical situation of one of the parties, whereby they may have waived their right to maintenance in the agreement, or they might have limited their right to receive maintenance as in the event of a divorce. But there's been a substantial change as it relates to their physical health. This does happen on a fairly regular basis. When the parties get older, they do get divorced. So in that situation, the court can look at the agreement and say the agreement is enforceable. However, the provision as it relates to maintenance or spousal support is something the court can readdress and say, no, under these circumstances, we're going to set that aspect of it aside, and the court can then use Illinois law to determine what another spouse would be entitled to as far as maintenance.
I'm sorry, you mentioned, for example, one equal
Depends on the jurisdiction of the court. So if the agreement itself says Illinois law is to apply, then Illinois law would apply no matter where the parties reside. And if the divorce case itself is pending in Illinois, okay? If the parties file a divorce in Illinois, it's enforceable in Illinois, the agreement. If the parties file a divorce in another state, that agreement is still enforceable by that other court using the laws of Illinois as it relates to those aspects of the agreement. So you would have a situation where you could have the parties move to Florida. They had an agreement that they signed in Illinois, but since Illinois law will be what will be used in the event of divorce, the nuptial agreement is signed in Illinois can be enforceable in Florida in the divorce case. Right? Does that kind of answer what? It's just a roundabout way of saying yes. That's the reason for the inclusion as it relates to the state of choice as to how the agreement is going to be enforced. Go ahead.
This might feel like the craziest question, but since you said earlier you can choose the state of which the laws apply in the agreement, can you choose the state that has the loosest laws?
You can, but why would you do that if you were the party that was going to be adversely affected in that situation?
Because you're shady.
Well, no. Well, then that would mean you're a bad attorney, okay? Because the attorney would immediately say, why would you choose the state of Florida, for example, where there's a limitation on maintenance or things of that nature, rather than Illinois? Well, if I'm the spouse that might want to receive that maintenance, I'm not going to agree to Florida being the state of choice for enforcement.
Which state is the most distributed for the?
You mean adversely to the party writing the agreement, or
The party writing the agreement? For example, the second one, which state would I want? Yeah, which one is the most?
Well, I can't address every state's laws as it relates to every one of those issues. With Florida or Texas, you're usually a little bit more conservative as it relates to that. Your rights might be a little bit more limited. Now, New York, New Jersey, Illinois, some of the East Coast states, much more favorable to setting aside these type of agreements unless all the requirements that we're discussing this morning are met. In those situations, it's a little bit more beneficial to someone who's looking to obtain maintenance or set aside an agreement. Okay, if that kind of indicates to you. Illinois is kind of in the middle, leaning more to the left, I would say, overall. Enforceability. You have to have both parties should be represented by counsel. This is critical. If a party's not represented by counsel, it doesn't mean that the court won't enforce the agreement, but the court's going to look very closely at it to make sure it meets all the requirements and enforceability to make sure that it's not unconscionable and it's in the best interest of both parties and there was no undue influence, coercion, threat. It should be negotiated, prepared in a reasonable time prior to the marriage. As I indicated earlier, don't be doing this a week or a day before the marriage. Okay, it's going to create obvious obstacles. And I've had cases where we start the litigation process and go through the whole discovery and exchange of information as we would in a normal divorce case, and they have a prenuptial agreement, and the court's going to say, you know what, we're going to let that occur until we get to the bottom of whether or not this agreement is enforceable. So the more time ahead of the marriage, day of the marriage, that you can have these agreements prepared, drafted, negotiated, the more likely it's going to be enforceable. Postnuptial agreements. These are agreements that are entered in between two parties after they're married. What's the difference between the two? In a postnuptial agreement setting, the court's going to look at it a little bit more closely. It's going to require that the parties have some type of consideration. What do I mean by consideration? Where each party gives up something to their detriment. In a regular prenuptial agreement prior to the marriage, the parties don't need consideration. They can agree to whatever terms they want as long as they're not unconscionable. There's been fair disclosure, and all the other requirements are necessary for enforceability or not. In a postnuptial agreement, there's got to be something that each party gives up as a detriment. What do I mean? That means that one of the parties says, I'm going to give you this asset in exchange for something else. That has to be specifically set forth in the agreement. If it doesn't exist and it's just a premarital agreement, the court can set that aside. It has to be in writing. It has to be complete disclosure of all assets and no coercion or threat or execution under duress, the same as in a prenuptial agreement. And again, counsel. You must have counsel in these situations. A postnuptial agreement, in my experience, where there's not an attorney on the other side, is highly suspect by the courts. The courts are going to say, their parties are in a relationship, they've been married, they've acquired assets, things of that nature, and the court will look at that very, very closely with personal counsel. And again, there can be no provisions in agreements regarding child support or children's issues as it relates to postnuptial agreements. So
Can a postnuptial be used to, for example, like if there's, inheritance or what would?
Yeah, and that was the next issue I was going to address. So postnuptial agreements are very common when there's an inheritance that's to be expected. Normally, with a prenuptial, you may not even have notification that that's going to occur as the parties get older, they acquire assets and things of that nature. In a postnuptial agreement, when people come to you for those type of agreements, they already have these issues that just arisen they want to address. Now, the pluses and minuses as it relates to entering that postnuptial agreement, again, are pretty obvious. If in fact you're a party to a postnuptial agreement and the party, your spouse says, I want to get this asset protected, they're doing that for the benefit of themselves and not for you. So the negotiation that takes place regarding a postnuptial agreement, since it does require that consideration or exchange of something and a detriment to each one of the parties, is very critical. All right, go ahead. See, if you acquire property through inheritance at any time, it's technically non-marital property. But the increase in value of that asset by personal efforts, by your income, or if you apply assets to increase its value, it's marital property that's subject to division by the court if it divorce.
Please add to
if you're working, say if you got an inheritance and it's an account A, B, C, or D, and then you make a deposit into that.
Yeah, you commingle any funds.
And just leave it and it naturally grows on its own. It's non-marital property. It's fine. But normally what happens in these type of situations, with postnuptial agreement, there's an indication where one of the parties is applying some kind of personal effort. So the effort that you apply in a marriage that increases the value of any asset, whether it's marital or non-marital, is divisible by the court in the event of a divorce. So the appreciation and the value of a retirement account that you had prior to your marriage, if you're still working during the marriage, that's going to be subject to division by the court. But you can address that in a prenuptial or postnuptial agreement to say that increase in value based on my contributions during the marriage is going to remain my property. And that's the beauty of premarital agreements. It allows you to protect the increased value of even those non-marital assets, including inheritances, properties, things of that nature. It allows you to protect what happened.
Bad increase of retirement account. Now you only look at the bonus.
No, not in a retirement account because it's going to be just your name. If you ever change over ownership into joint tenancy at any time during the marriage, you convert that property into marital property. But a prenuptial agreement can say, even though we do that, we're going to both agree that that's my non-marital property. So many of the agreements include that type of language. It specifically says, even if I commingle this asset A, B, C, or D, it remains my non-marital property. Now, will the party agree to that? Sometimes they don't. And that's part of the negotiation process. Any other questions?
What do you suggest for people in this day and age that are getting engaged? Thank you. And postponing or deciding to never get married, but I mean, for all intents and purposes, live under that same belief system. As a clinician, I know a lot of people in that position.
Right. Under Illinois law, there's no common law. So if you live with your partner and receive all the benefits of living together and you separate, you have no interest in their property, no interest in their income, no interest in anything. And most people who cohabitate without a legal recognition of that relationship under Illinois law have no rights. We're not a common law state in Illinois. There are other states where you can do that. Illinois is not. Now they're contemplating. I know the bar associations were looking into it. We're looking into maybe some new statutes that would allow us to become that type of a state, but it hasn't happened yet. So the important takeaway from that is if parties want a benefit from the relationship where they're cohabitating and not married, they don't have a legal civil union, they have no interest in other parties' property or income or maintenance or support.
Even if they buy things together?
If they buy it together in a joint tenancy, you've got to go to court and file a partition action to sell that property. It's a nightmare. So when people ask me, what are my rights when you cohabitate? I say, good luck. That's my short answer because it's true. Because it doesn't help me because I send it to Lance who does the partitions. So from that standpoint, it's more of a protection for the parties. Now, children are different in that type of situation, of course, for child support. If you have a child as part of the marriage, you can start a parentage act and you're going to get child support. But as far as division of property and maintenance, that answer is no.
there ever a situation where you'd recommend the postnuptial agreement?
Actually, I've got a few cases right now where the parties still want to live together, but they want to make sure their assets are separated one basis or another. For example, one party is the breadwinner, and the other party decides they want to entertain a new area of interest. They want to be a musician, for example, and they were formerly in a financial aspect, and now they're making $50,000, and their spouse or civil union partner is earning hundreds of thousands of dollars. Now, the party can come to you and say, look, we don't want to get divorced necessarily, but I want an agreement that protects my efforts and my assets just because my spouse decided to do something else. And if the other spouse agrees, you can do the postnuptial agreement. So that's an example where they don't get divorced because that still gives you benefits from that party as it relates to insurance and other things of that nature. It's very old. Anybody else?
To pick up.
All right, thanks a lot.
Thank you.
Vito's got to run to McHenry County for court. So,
Is that what happened here?
what's that? Hi, I'm Annette Corrigan. I'm one of the family law team members here. And just like Joe and Christy, I am a trial attorney, as you know, for in divorce in the family law arena. But I also, over the last few years, although it had been out there since the 1990s, I've heard about another process, another way to go about getting divorced, and that is the collaborative process. So I went through the training, and I've had some collaborative divorce cases, and I want to talk to you guys today about it because we're still, even though it came about really in the 1990s, we're still trying to get the word out to people that there's another way to go about getting divorced. It kept, probably because I'm touching the button.
Yeah.
Right? I'm touching the button. So, and I've had cases, I think we've all had cases where not everybody who's going through divorce hates each other, right? There are people who they just don't no longer want to be married. And so even in whether they go the collaborative divorce process, if you have the traditional route, which is the courtroom, going through the courtroom process, you still, as attorneys in family law, you collaborate, you cooperate, you try to get along, try to reach a settlement. The collaborative divorce process is different because you don't start off with filing a petition for divorce. What you're doing is you're entering into an agreement with your soon-to-be spouse to go about your divorce in a collaborative, just like it sounds, a cooperative way. And it starts out with, rather than a petition being filed with the clerk of the circuit court in the county in which you live, you're actually sitting down and you're signing into a collaborative divorce agreement, okay? This came about in the 1990s when a burned out family law attorney named Stuart Webb from Minnesota decided that he had had enough. There were many situations where going through the court process did not make any sense. And he wanted to initiate and originate a new process. And that's how it came about. Under Illinois law, we adopted this process, and it's part of the Collaborative Process Act. And it became effective in Illinois in 2018. Now, both parties, as I said, have to enter into a collaborative divorce agreement. But that also means that both parties have to engage collaborative divorce attorneys. So, for instance, if you don't have the training as a collaborative divorce attorney, then you can't, if you're hiring one, but your spouse's attorney is not a collaborative divorce attorney, they cannot engage in this process. The whole idea of collaborative divorce is, you're there, you both agree that you're going to be respectful, you're going to be transparent, and you're going to cooperate to achieve the end result, which is your divorce, but in a respectful and, just more open way. A lot of times people want to go this route because they hope to really protect, I guess, the relationships that they have, right? You have children together. You're going to be with that person one way or the other until those children emancipate. So it really does. A lot of people find it really helpful in situations where they have children going through the divorce process with them. Next one. So as I said, the first step would be that you would each engage a collaborative divorce trained attorney, which I am. And then you get together. The next part is you're going to assemble a team of people. So you have an attorney on both sides. We're still your advocate. You hire us as your attorney. We're still your advocate. We're still looking out for your interests. But we're there and we're putting on a different kind of hat. We're not going to go in there ready for the battle. We're going in there to advise you on the law, to let you know what your rights are. But we're going to go about it in a way that we're going to get along, try to get along, play nice in the sandbox, and disclose everything as far as like financials and your children involved. What are your goals individually for those children, and how do you see your parenting relationship, proceeding as the children age? So some of the people that will make up our collaborative team would be, in addition to your two attorneys, might be a mental health professional, whether that's a child therapist or a divorce coach or someone along those lines, and a financial expert. A lot of times in almost all the collaborative divorces I've done, we'd have a financial expert. That's not to say that if you decide to go the collaborative divorce route, that you need these additional experts. But we find that when you have these other people involved in the process, it really helps to make the process go more smoothly. And that's the whole point. At the first meeting, we get together, everybody's at the conference room table. Rather than being in a courtroom, you're meeting in a conference room at one of either the attorney's offices or the counselor's office. And we're sitting down and we're going over the collaborative divorce agreement. And that sets forth the terms that say how we're going to each behave, how we're each going to act, and that we are making a commitment to go about this in an amicable way. Okay. And we will, at that time, after signing the agreement, we go over each party's goals. And I actually have my clients, before we even enter into that meeting, I have them list out the goals that they have. They have them write them out. And then when we sit down, we're ready to go, right? We know what they hope to achieve. And we're going to be there listening and hearing what the other side hopes to achieve. The parties sign the agreement. And, it's really a very nice, casual, informal experience. You bring the guard down. As I said before, you're not going in for battle. You're going in there to listen to one another. You're putting everything on the table. A lot of times the attorneys will engage. If it's a little bit quiet in the room, we'll ask questions. I know many times I'll say to the other side, we've heard what my client has to say. We'd really like to hear what you have to say, and we're there to listen. I find so often too that the mental health professionals are really, really good. I'm not trained as a mental health professional, right? But yes, right. They come in and they know the way to prompt the parties to open up, to be part of this. They've already made the decision that they don't want to battle it out in court, right? For whatever reason. Number one, they just don't want the emotional stress that goes with that. Could be a financial reason that they want to go the collaborative route. So we sit there and we talk about it, knowing that in mind, we want to reach those final agreements so that we can ultimately become disentangled as part of our divorce, right? That's what both parties want. They want to disentangle from one another, preserve relationships, and get to the end goal, right? The divorce. As soon as possible, and as keep it as financially and economically viable as possible. After the court does get involved at the very end of the divorce process, even though you go the collaborative route, ultimately, once you have your agreements, whether it's the parenting agreement or a marital settlement agreement, which deals with the financial aspects of a divorce, in the end, those documents are drawn up, but then they're submitted to the court to be reviewed, approved, and then entered. Only by a court's entry, their signature, their entry of that final judgment that incorporates the agreements that we all worked out, does the divorce become final. So, but we'll get into some of the aspects of that make this process the better way to go in the end. Go to the next one. So I already mentioned this, that the participants typically in a collaborative divorce are the attorneys who are collaboratively trained, divorce coaches and even the therapists, whether it's for children or the parties themselves. They are really important to the process. And that financial neutral. The financial neutral is someone who is going to be there to say, okay, I'm going to need each of you to get me your financial records, right? They need tax returns. They need to get your pay stubs. They're going to need to see what your assets are. What is your debt? That individual helps to gather all of the necessary financial documentation that's going to be needed to evaluate, to identify, and then as part of the divorce process to decide how are we going to allocate that marital estate between these parties. And so they are very helpful as far as getting, helping the team gather that part of the documentation and the information. And then I haven't had a child specialist yet in any of the cases I've had. I've had divorce coaches and I've had family therapists. I haven't had any unique situations where there's a child that's maybe struggling. There's some unique child-related issues. But every divorce is different. Every family situation is different. If the team decided that might be a benefit to this particular divorce, we might recommend to the parties that, have you considered maybe bringing in a child specialist to help us all, bring that expertise into the equation. So this is just a chart I put together to kind of show you the differences between if you went the litigation route versus the collaborative route. Rather, the setting of course, for litigation, you're in a courtroom, right? You're in the civil process arena versus with a collaborative divorce, you're in conference rooms. It's much more comfortable, more casual. In litigation, the judge is the person who's ultimately deciding when there's disagreement, what's going to happen. Where in a collaborative approach, the spouses, with help from the experts, the team, are going to be the ones ultimately making those decisions and coming to an agreement. Courtroom experiences. In Cook County is probably the worst in terms of it can take a very long period of time. I've had cases that are as old as 3 years old in Cook County, and the divorce is still going on. And then there's other jurisdictions like DuPage or Kane, where if your case is now coming on to about 10, 11 months, the judge is saying to you, I'm setting this for trial if you don't have an agreement for me in the next 30 days. They move their cases along. Different jurisdictions have different timelines and different expectations. So again, the collaborative approach, what's nice about it is the parties are telling us the timeline they want to follow. Okay. For instance, they both might be motivated to get their divorce done. So they may say, we're ready to go, and we get in that first meeting and they're saying, okay, well, now we know what our goals are. Now we know what sort of documentation we need to pull together. And next thing you know, we're plotting that out every 2 weeks, every 3 weeks or so, or maybe it's every month. We're getting together until we get final agreement. The only thing that would really hold up the plan of the parties in terms of a timeline would be making sure that the other people on the team have the availability. Okay, but you're setting the pace in a collaborative divorce process, not the judge, not the court. Cost is a big factor for going the collaborative route. Have any of you, if any of you have been involved in like litigation, there's part of the process, of course, is investigation. We call, it's called formal discovery. That's where, not everybody's being transparent. There's information or documentation that's not being disclosed. Next thing you know, depositions are being taken, right? Or they're sending out written interrogatories, questions to the other side because they're trying to get that information. And of course, Illinois law dictates, the rules and the parameters within which you have to comply with the other side's requests. The other side may say, I want you to go back 3 years and get me all your documents on every asset you have. Bank statements, tax returns, credit card statements. I mean, it just gets very cumbersome and very time consuming. If you get into the formal discovery process, you're going to be, you're looking at 2, 3, 4 months where you're just going through that process. In collaborative, and of course, there's expense that goes with that, not just time. So, it's much more cost efficient and time efficient because in collaborative, you're signing in the agreement that you're promising each other that you're going to be fully transparent. You're going to, if something is asked for, if somebody says, I know there's this account out there, I don't think any statements have been disclosed yet. The expectation is you're going to be forthright. Okay. Anything that's asked of you, you're going to put it on the table. And then, of course, just the tone. And you're going the court route, the civil process route. You're going to it's just more adversarial. I, as a trial attorney, have a different hat on my head, right? I'm much more guarded. I'm not just sharing information with the other attorney. I'm strictly there to, I'm more of the adversarial, the combatant, right? Looking out for my client's interests. And that's not every single case when you go the courtroom route, but, a lot of times it's just more rigid, much more formal, much more careful about disclosure. And in the collaborative process, you're there to be, while I'm still your advocate, while I'm still looking out for your interests, I'm also changing my approach and the tone to more cooperative and more just respectful and open, transparent. So the benefits, we've talked a little about them already, the cost savings and efficiency. Let me look at the next one. You avoid the expensive court fees, for instance, like I said, the depositions and, even going to trial. So we were talking earlier, a lot of us practice in multi-jurisdictions, and we can only do that since COVID because so many of the jurisdictions have gone to Zoom court. Well, if you have to go to trial, if you have an issue, maybe your spouse isn't disclosing all the financials that they should, and then your attorney has to bring a motion to compel, right, to get them to say to the court, make him or her turn over these documents that we don't have. Now you're filing a motion, the other side gets a chance to respond, then you're showing up to court, getting time away from work, at the courts, a lot of times their schedule and not yours. It gets expensive. It's a lot of time that's consumed in going that route. So again, it goes into how the pace of a collaborative divorce is just it's more smooth. It can fit into your schedule, and you have more say in how it proceeds. The standard, and I just included this, but as part of the participation agreement in a collaborative divorce, it says, it's very clear, full disclosure. We agree that during the collaborative process, each will make timely, full, candid, and informal disclosure of all material information related to this divorce, whether requested or not. So the expectations actually in the agreement that you sign, that you're going to be transparent, you're going to disclose everything. And it goes on from there. The whole point is that it's full disclosure. Getting the hang of this, Jackie, with I told her I haven't had to do one of these in a very long time. Benefit to less emotional stress, better relationships. And nobody in here has to be told. You have children, you're going through a divorce, right? That spouse is going to be part of their lives. They're going to be part of your lives to some extent because of those children. If you can preserve any part of that relationship, you're going to better be able to do that through the collaborative process. Let's see. As far as privacy is a big thing. People don't, when you file a divorce with the clerk of the circuit court to get that process started, those are public records. You have a hearing on some issue that has come up in your divorce. You're filing a motion, they get a chance to respond. That's public record. People can pull up your divorce. They hear your neighbor down the street hears that you're going through a divorce. That's public record. They can pull it up. They're nosy, right? They want to see what's going on. Well, the collaborative process, you haven't filed a petition yet, right? You're doing all of this in a conference room and not out there, not exposing everything to the public. So for a lot of people, the privacy piece of a collaborative divorce is really appealing. And then the other part of it is, I can't tell you how important the emotional support that the parties and the cases I have had get from having that mental health professional as part of our team. That's been so important. As family law attorneys, sometimes we feel like our clients treat us like we're therapists, and we're really not qualified for that, but that's how they treat us, and you do the best you can. In a collaborative case, you have that mental health professional there. They're bringing that expertise to this whole process. They have been invaluable to so many of the ones that I've had. So another great reason for having, for going the collaborative route. And then I think this is my last. There's many benefits, I think, but just real greater control and being able to do things, letting the parties really control it rather than the courts or the attorneys, right? different cases in the court process are different depending upon the attorney on the other side. Different attorneys approach things differently in the courtroom. You could be more collaborative, more cooperative type of an attorney, and then the other side hires the most aggressive person they can find, right? Who's going to just take it to the mat at every turn, which increases costs, which increases time. And it just, in the collaborative world, both attorneys are coming in saying, we're both on the same page and we're both going to, go about this process the same way. So it really sets the expectations. Yeah.
As a clinician, I can tell you that it's so true. And it is when people go into that mindset of, I'm going to make you whole, that drives that desire to find that person. And they do not understand, when I hire you, you work for me. And that's the first collaboration and understanding. If you just know law, you really navigate the law to get to where you need to go. I love collaborative law. I love it.
So and I'm just curious, who in here has heard of collaborative divorce, the collaborative process? So getting the word out, I was happy when this came up to be able to speak on this because it is such a better approach. All of us that work in family law, of course, are for families. We're for families, we're for children, and preserving that. I can speak for my colleagues. We are all very much about protecting our clients, protecting as the best we can the family unit and children's interests. Divorce is difficult. And when I learned about the collaborative process, I signed up as soon as I can to get in the first class because I really do feel personally that that's where all family law matters should be handled, not in a courtroom, but in a conference room. We're looking at each other and we're communicating with each other. Oh, sorry. Oh, am I supposed to wrap up? Right.
Well,
okay, sorry. Okay. Yeah, he had a question.
Wondering, how many states have? Do you know how many states?
So I'm not sure the exact, it's adopted throughout the United States. I don't have a list of all the states that have it, but it's been adopted throughout the United States.
And in Illinois, would you say in the last year or two, what percentage of divorces go this route?
So I'm not sure of the number. That's a good question. I should find that out, but I can get that from Collaborative Divorce Illinois, which I'm a member of. But I can tell you with that one, out of all the calls I get in a month, I would say a third of the people that call me want to know about collaborative divorce. And if not collaborative divorce, they want to talk about mediation, right? As a form, another way to go. I need to wrap this up, so I better stop talking. There is something that you all, and I'll go to the next slide so you can look at that while I'm finishing up. So it's not going to be ideal. It's not a route to go if there's domestic violence, if there's substance abuse, if there's some really serious issues. Collaborative divorce is not going to work. You're going to need probably court intervention and court orders to get some things in place to protect family interests, right? So that's not going to work if those things are there. If you get somebody that comes in and says they are, one of this, my husband will never agree. He's so difficult to work with, but he wants to do the collaborative process. I'm going to be making an inquiry of the other attorney saying, have you really talked to him? Do we really know if this is going to work? Because the downside of, there's one downside to collaborative, in my opinion. And honestly, I think there's only one. If you have parties who are really interested in getting this done and being cooperative with each other, if it fails, if your collaborative process fails and you don't reach final settlement, the attorneys who are representing you in the collaborative process, you can't have them for your divorce. You've got to find new attorneys. So that is a downside if it doesn't work. But I know as I've gone and done more and more collaborative, I'm really screening my clients to make sure that this is a route that it makes sense to have this person go the collaborative route, and then making those inquiries up the other side. So that's really all I have to say. I've had a really good experience with collaborative divorce, that process. It's not for everybody, but if it's something that you're interested in, or people who are interested in it, definitely have them look into that, because it's the way to go, I think. And I think it really preserves, like I said, whatever's left of that family unit, those relationships, it's really the best route to go. Okay. Does anybody have any questions real quick? I know I get chatty, so.
What is the biggest difference between mediation and collaborative?
So in mediation, you're having a person who's a neutral, who's listening to both sides, right? And those sides can come in with their own attorneys if they want to. I've done it both ways, where I come in and I'm representing another party, and the other side has their attorney too. But mediation is where you have a person that's helping to work through the issues with the parties, but it's not this team approach. It's not where you're going to have like the other benefits of the other experts. You're not bringing in a financial neutral. You're not bringing in the mental health expert. I mean, a lot of similarities, but you're having that one person who's sort of almost like a judge, but not taking any sides, and really they're there to help help the parties find a center to achieve a settlement. Okay. Anybody else? I want to make sure, because Christy's got to go to DuPage this morning. As I said, we're always running to different courts if we have to. That's not on Zoom. DuPage is not Zoom. What's that? DuPage is not Zoom. We'll have to stretch. Okay. Thank you all.
Okay. Good morning again. My name is Christina Buffalo-Helpast, and I'm here to talk to you about child custody, which is the thing that Annette and Joe referenced in each of their presentations. We can't provide for child custody in prenuptial or postnuptial agreements. When things get dicey in child custody cases, it's not right for collaborative divorce, which brings us right squarely to the courts in Illinois for child custody. And the first thing you need to know about child custody is that it's not called child custody anymore. It's called allocation of parental responsibilities. And that term is something that the legislature gave us in 2016 to take effect in 2017. And so if you're professionals advising clients, it's important to know that anything that we saw prior to 2016 in terms of laws referencing custody, those laws have been repealed and replaced. So you want to be careful if you're assisting clients that the word custody and statutes relative to that prior to 2016 not being used anymore. So it's an important thing to be cautious about. So as we look into allocation of parental responsibilities, what's the artist formerly known as custody, we have two major pieces here. The first is allocation of significant decision-making. Those are 4 areas that parents can either make decisions solely if they have sole allocation of parental responsibilities, or jointly if they have joint allocation of parental responsibilities. So we'll get into that in a little bit. And then the other piece is parenting time, which we'll also discuss. So if the parties cannot agree on allocation of parental responsibilities, custody, as to major decision making on these 4 areas. Those areas are education, medical and mental health and other dental care, anything in the medical field, religious upbringing, and extracurricular activities. Those 4 areas are what comprise are what make up major decision-making authority in Illinois. And so if 2 parents going through a divorce cannot figure out whether or not they should be making these decisions jointly or solely, we go through the process. First, the court requires mediation. We heard a little bit about that from Annette, but that process essentially is sitting down with somebody and trying to work out our differences. The county actually provides free mediators, or private attorneys can do it for a fee, which is a couple $100 an hour. I like to say in family court, you get what you pay for. So the mediation that the county provides is appropriate where essentially you don't think it's going to work very well. And if you really feel like your clients are able to mediate, if they're able to come to the table and get things accomplished, one person isn't going to hold out on everything, then the private mediation might be more appropriate in those circumstances because it's worth investing the money, essentially, if you feel like you get a return on investment. If you don't, free mediation is the way to go. The next step, I want to point out, these 2 are generally considered interchangeable, but they have some important differences that I don't know that we need to get into in the few minutes that we have left. But the court, if mediation is not successful in bridging the gap between the parties' differences, the court will appoint one of these 2, a child representative or a guardian ad litem, to come in and represent the interests of the child. That doesn't mean that a child is sworn in as a witness and takes the bench and starts testifying in court. What it means is that an attorney is appointed to go visit the child at home, have the child come into their office with mom, and then have the child come into the office with dad. They can assess what are the differences when they're with one parent versus another. Maybe talk to grandparents, caregivers, daycares, school teachers. that sort of thing. And so they'll do what's called an investigation. I mean, it really is an investigation where an attorney looks into what's in the child's best interests. Yes.
What if it's the father? He doesn't really.
It's still appropriate if you can believe it. I mean, so even though your child may be not exactly great at giving an interview at 2 years old or 1 year old, they'll be talking with the child rep or the guardian ad litem, or otherwise known as a GAL. You might hear that. So they'll be talking to classroom teachers, seeing how they interact with a parent. So we would have cases where a child would be brought in to the attorney who represents that child into the office with mom, and then maybe a week later come in with dad. So the attorney can assess, how are they playing differently? Is the child as comfortable with mom as they are with dad, or vice versa? Really, there's all kinds of ways that we can assess a situation without actually having to do like an interview, Barbara Walter style. So if this is unsuccessful, if the parties cannot accept the responsibility, the recommendations made by the child representative and the guardian ad litem, then we start getting into really expensive territory, which is court-ordered evaluations. You might want to just jot this down if you're looking at representing people who have these issues or working with people who have these issues. The court-ordered evaluations have these names. There's one called a 215 evaluation, and there's another one called a 604-10B evaluation. Those evaluations determine, with a recommendation from an MD, a psychologist, PhD level, PsyD level professionals, looking into the circumstances of what's in the best interests of the child. What are the parties' mental health considerations? What are their relationship considerations, other pieces that come into play that a judge or an attorney simply are not qualified to do. And that's as you, it should be sounding to get that it gets more and more expensive as we go, because one of these evaluations, these court-ordered evaluations, could cost anywhere from $10,000 to $20,000.
So last one I had was 30, Christy.
Yeah. So these are very expensive things. And I want to point out, it should be noted that when we're talking with prenuptial agreements, when we're talking about divorce, there's a cost-benefit analysis to these considerations, right? If we're protecting a business that's worth $50,000, we certainly don't want to spend $60,000 trying to protect that business. If we're talking about dividing a marital estate in a collaborative divorce that's worth $100,000, we don't want to spend $90,000 doing it. There is no cost-benefit analysis for child custody. Yes.
As you're talking about these different options, I was thinking about something where so many times, like you mentioned toddlers, but like 5-year-old, 8-year-old, 10-year-olds are manipulated by
right.
And so like it's so hard for them to, like, of course they're going to be comfortable, like for example, with them send all kinds of things to try and, you can, do this and so I'm assuming when you get into some of those situations, it's really hard to get it back.
Yes, and you're absolutely correct. When it's not just about the family and the circumstances, but we're talking about the personalities of these individuals who come into play, whether or not it's someone doing a court-ordered evaluation, someone doing guardian ad litem work or child representative work, or even just the judge. We get the personality of the person in the case, and it literally comes into the elements of the case. I've had cases that were made much easier by the demeanor of the GAM, by the demeanor of the judge. And I've had cases that were much more complicated because of that same dynamic, because the person, is offended by the notion that someone would get, 3 dogs in their house or a new dog to like appease a toddler. But there's a lot of personality mixed into family law, and it's unavoidable. So it's something to be aware of insofar as if you're a clinician or if you're a financial advisor, child custody proceedings are no cakewalk. I often joke with clients that it's like essentially You don't want to be in child custody proceedings if you don't have to. And it can be as random as having the person who helps you with your driver's license renewal at the DMV making decisions about your children. That's not a personalized one size fits whatever, it's a one size fits none approach. The courts are doing the best they can. It's often not a perfect system, not getting perfect outcomes, but it's the best that we can do under circumstances where there's a lot of conflict, where there's a lot of cost, and there's just a lot of emotion. So if in fact we go through this process of mediation is unsuccessful, the recommendations are unsuccessful, and we need these court-ordered evaluations. What's coming next? If we can't get an agreement between the parties by the time these are all completed, what's coming next are court hearings and where a judge makes a decision. And that's the kind of situation that I'm talking about. This can get very complicated and expensive because to get to a point where a judge makes a decision means that we have to sit in court for 1, 2, 3, 5, 10 days at the cost of several $1,000s a day, in addition to the preparation to get us ready to be in that courtroom, to get the judge ready to be knowledgeable enough about this family to make a decision. All of that costs money. And again, there's no cost benefit analysis. We can't say what the value is of having your child with you every other weekend. It's really complicated and expensive. We want to avoid it wherever we can. In addition, if we finally have parents who are able to get an agreement or have some type of decision-making authority together, we've seen some good progress in co-parenting therapy with the parties who are already divorced, going to meet with a therapist once a month, once a week, or somewhere in between to talk about the issues that they encounter and have someone who's a mental health professional guide them there. I'm sure you've heard the best, what's in the child's best interest as being a name, a moniker of how we look at family court. And that's still good law. The best interest of the child standard is what we apply in many aspects of child-related litigation. And when we're talking about that, it's this amorphous term, best interest. What does it mean? But it really means that we want to maintain this important term, status quo. If mom is always the one to take the children to the doctor, dad's always the one to take the child to soccer, the court wants to maintain that stability for the child. Mom will continue going to the doctor. Dad can continue doing with the soccer. If there's a problem, certainly, and it's posed to the court can make changes. But all things being equal, the court wants to maintain what's the status quo for the child for as few interruptions as possible. And we're looking at healthy relationships. It's not, again, these are amorphous concepts that's hard to put your finger on. But if mom and son are always squabbling and getting into situations where it's boiling over and the neighbors are wondering what's going on, or the other children are affected, or the police are called, that's not a good sign in court litigation over custody. It really isn't. So healthy relationships are really important, and it's an important piece of what we're dealing with in court. If the relationships are not healthy, and if these are your clients or these are your circumstances or your children, I highly recommend getting those things resolved, or at least started to be on the trajectory toward a resolution prior to starting the litigation. If a parent cannot connect with a child, that's not a good place to start a case. In addition, as we encounter parents who have money troubles, whether it's because of litigation, because of substance abuse, because of bad financial decisions, if a parent doesn't have the ability to care for a child financially, it can weigh into the picture. I'm not saying that a parent has to be wealthy enough to have custody, but a circumstance, for instance, where a parent moves out of a home and gets a studio apartment so that they can have their own place to strike out and get some independence or some freedom from the other spouse, that's not a good place for parenting time. That's not a good place for kids to spend every other weekend. We want to look at people having at least every child having their own bed, ideally having their own, sleeping space away from a parent. And the less of that you have, the less financial ability to care for a child, the more rocky your case is. So it's an important piece to be able to create that stability that a GAL or a child rep or a court can see that someone actually has the ability to do so. Another piece is siblings. The court does not want to separate siblings unless there's a real reason to do it. So if, mom has children from a new relationship and the child has a close bond with those siblings, that's going to put a thumb on the scale about how much parenting time each parent should have, because in one place they could have a good relationship with siblings, in another household they wouldn't. And so that's an important piece that comes into play. How are we doing?
We're a little over.
Okay. And so we did go over this a little bit: education, healthcare, religion, and extracurricular, joint. Those are the decision-making rights, and someone who has sole allocation makes these decisions without consultation with the other parent. That's appropriate where there's domestic violence or some really tough conflict between the parents. The courts are going to say if the parties can't get along, they shouldn't be making joint decisions together. And joint decision making has become the fallback position. Courts want to see parents making these decisions jointly. The court in the court and family law in the domestic relations division has some underlying tenets that it adheres to that we don't necessarily see in other courts, right? We don't see in law division the court saying, okay, we want to have X, Y, or Z. In family court, it's different. The court wants to see the child have a relationship with both parents. It wants there to be a lack of conflict in the child's household. And those are all about the best interest standards of the child. And an important piece of eliminating that conflict is having parenting plans, essentially agreements between the parties that make things clear. The more clarity we have, the more rights that we have established, the easier it is to keep conflict down. And that's what the court wants to see. It doesn't want to see two parents who duke it out in court, can't agree on anything, getting sole decision making just to come back 2 weeks after the divorce with their next conflict. That's not a circumstance that's right for joint parenting. And we're going to see, if that were to happen, we would see a sole allocation coming out of there eventually. Parenting time that we're seeing right now has changed over. I've been an attorney with Lavelle Law for 16 years. In that time, we've gone from having the non-custodial parent having every other weekend, Friday through Sunday, and maybe one night of the week for dinner. That was a standard probably when I started in 2009. I would say that was probably more appropriate to being like what the standard was. Here we are in 2025. The court wants to see joint allocation of decision making. It wants to see each parent having a full weekend, Friday night or Friday after school, all the way until Sunday night or Monday morning. So the parents don't have to interact. So those weekends are now more and more looking Friday night through Monday morning drop off at school, and 2 nights overnight for each parent, maybe Monday, Tuesday with mom, Wednesday, Thursday with dad. You may hear that. That's called a 2-2-5, or the party swap. So they'll have, if I had Monday night and Tuesday night of this week, I'll have Wednesday night and Thursday night of next week. That's called a 2-2-3. So if you hear those terms, that's what they relate to. The number of overnights midweek, and 3 always refers to the weekend because it's Friday night, Saturday night, Sunday. And the court is going to consider the work schedule of parties. If we have a police officer, first responder type schedule, we're not going to be seeing it every other weekend as a standard, but there's lots that we can do to modify it. The person certainly has to assert that need. And then if the child has therapies or whatnot, that could change, the ordinary schedule that the parties follow. And distance between parents. It's an important piece. We have, I've seen several cases recently where due to financial constraints or other issues, one parent will move, from the Northwest suburbs where we are to the city of Chicago. and then want 50-50 parenting time. Well, how are we going to manage to do that? It really does impact what someone's parenting time schedule could be by how far away that they live. And these are practical considerations that seem like they shouldn't get in the way of a relationship, but the court's really looking at what's best for the child, not what's best for the parent. And so we're getting down to the end here. Once we get this all done, signed, inked up, and entered with the court, you or your client should know we can change it at any time. So it's all up for grabs. So really, I say that, probably like it's an easy way to remember is child custody, child support, allocation of parental responsibilities, parenting time. They're all modifiable. They're all modifiable in case someone gets what I like to call the pregnant DUI, right? But the whole circumstance comes down in one fell swoop where, someone gets a DUI with their kids in the car. They can't expect that they're not going to have changes to their parenting time or their child allocation if some bad thing happens in the child's life. So what the standard is, if someone wants to make a change to child support, parenting time, allocation of significant decision-making, we want to be able to tell the court there's been a substantial change. Something in this child's life has changed significantly, and we need to make changes related to that. That can be a job loss. That can be a relocation. That could be a mental health issue for someone in the family. And sometimes in our agreements, frequently in our agreements, we say that the parties have to go to mediation first if there's something that comes up that is problematic. But certainly if it rises to the level of emergency, that mediation could be off the table. We want to file for a change in custody agreements, parenting time, and whatnot. There's going to be a motion filed to kick off a new round of litigation under the same case number in the same case, even though the parties are already divorced. So I want to make sure that that I give you, you've got this here. I don't need to go through each and every element of it, but just as a guiding value that I think really is important. What I try to explain to my clients as an attorney is that one, conflict's never good for a child. We know this. But again, we have to assert our rights to the other person clearly so that they don't trample upon them. When my clients encounter issues with their children, I often recommend you should handle it the way you would handle it if the marriage were still intact, right? For instance, if a child's sick one morning, they're supposed to go to school and they're supposed to go to dad's house after school. What are we doing here? Some people want to look to their custody judgment. What does it say? What are my rights? And my first advice is know what that thing says, but try to do what you would do if your relationship were still intact. If you were always the parent who stayed home with the child and the child's sick, stay home with the child. I ask your ex if you can do just that to keep things what the child knows as normal. If there's a circumstance where someone gets in trouble at school, we don't want a situation where a parent is hiding the ball and not telling the other parent because they don't want to get themselves in trouble. Whatever you would do in your relationship prior to the divorce is the way that you should handle it. And, probably in most marriages, someone would say, hey, our son got in trouble, let's go meet with the principal. That's what you should do even after the divorce. It doesn't mean that, now that you're divorced, you change the way you deal with everything. I find that when parents take that approach, that they do what they would have done if the relationship were still intact, the judge is far less likely to be frustrated with their choices. If it's focused on the child, if it's focused on doing the right thing, keeping things normal for the child, we're going to get a lot more traction that way. So in conclusion here, the child's best interest still is the important piece in Illinois. The word custody is out. They gave us this long, title, allocation of parental responsibilities. Court is still expensive. Definitely seek legal advice from me. And my cards are up here. I always tell clients and prospective clients, you can call me on my cell. You can text me on my cell. I'm a texter. You can reach me at any time. And I really mean that. If there's an emergency, I don't mind a call on a Saturday. I don't mind a call on December 24th. I would rather deal with it right now than deal with someone's bad choice 2 weeks from now or on Monday morning. So any questions that I can answer for any of you?
So what age are the custody laws going to affect? So you feel that kids are out of the house or?
When did they go? When did they stop being in effect?
Not independent of the parents or?
So age 18, bright line, like, yeah. So if someone can vote, they're not subject to their parenting time, orders anymore. But there is that gray area between the age 18 and 22 where they still have certain obligations if their parents are paying for them for college. So the court can require each parent in a divorce or separation issue to pay for college. And then the child has some obligations within that for them to keep on getting that tuition. Did I answer your question? Okay, perfect. Any other questions?